Hi, my name is TJ Scott. This is my Chapter 4 Business Law video summary. Going to do my best to change these videos up. Felt like I was really summarizing after reading the email. Makes sense. Going to more give my opinion on the things that I did learn, the things that we had to study, the things we had to read, evaluate, and obviously the homework, which includes all of those. So Chapter 4 was on alternative tools of dispute resolution. Essentially, the legal system, but through a different light. Basically, looking at different ways that two parties or three parties, whatever it may be, may come to an agreement and then a resolution from there. Overall, there was a discussion on alternative dispute resolution, which is ADR, which includes all of these dispute resolution tools, negotiation, settlement, private trials, summary jury trials. A lot of this was looking at the differences between all of them, not necessarily the actual factual things behind the cases, not necessarily the things that we were trying to evaluate, but rather the differences between each. And I felt that the differences, for example, between arbitration and negotiation and settlement, looking at the differences really helped me and allowed me to understand the power of each one. It's a lot easier to learn these things. For example, when you're looking through the book, there's just definition after definition. Arbitration's right in front of me right here. There's 2 or 3 paragraphs on arbitration, a couple pages. It's much easier for me to learn these things when I'm looking at the homework. For example, the homework had a lot of questions, as well as the test quiz, whatever you want to call it, also had a lot of questions on the differences between these things. And evaluating the differences between them really allowed me to understand the importance of these situations. For example, I would not have any clue on the uses of any of these things just by reading the book. Obviously, there's uses in there, but I need real-world situations, and those are utilized a lot in the homework, as well as the tests and quizzes really make you think. Excuse me, the book's really a reference point, which was perfect. A lot of the things that really what it came down to was third parties, whether or not they were involved in the negotiation process, and then another part, big differences between all of these resolution tools, forms, between these disputes is the legal portion of the resolution tools, whether or not the law is involved, whether or not they need to be involved, what needs to be recorded, does there need to be a third party present. That was a big piece in all of this. When we were analyzing the differences in the homework, I found it really easy to just put together the differences as opposed to the relationships between all of the different tools. When I did that, you were able to tell what's used here, what's used there. Is there a third party present in mediation? Is the third party necessary to record? With litigation, how active is the legal process? How active is the examination of being recorded? And then another portion of this chapter was juries, private trials, different things like that, which once again went into on the homework with the private trials. The homework was complicated to me. Not complicated to do, complicated to understand. Nothing with the questions or anything. It was complicated to kind of pick apart the legal verbiage that was used. Really had to break down each sentence, each paragraph to find out what was really being said. I found myself the best way of doing it was taking notes on each sentence. So breaking it down into layman's terms, and then it was easy to understand from there, and then reevaluating what I was taking from the essay or take on the case and the situation with the contracts, and then turning that back into more legal terms when we had to reevaluate the essay. The essay also had a lot of different things involved with argument's sake. A lot of times I wasn't really sure what side to argue. I felt there was a positive and a negative side, and I was willing to do both. I felt I took the positive side, and I kind of stood with that, which made it a lot easier to understand and comprehend. Thank you.